Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. Today's topic, continuing my series, this is part 2, of some questions and my responses in a telephone consultation. So, yesterday I depicted the scenario, an adult child, and, I'm morphing facts, right? He could be she, mother could be father. That's not really the important thing, and I'm not divulging prospective clients' information. Adult child, telephoned, parent is in the hospital, is going to a rehabilitation center to get physically a little bit stronger for the probable return home. Right, that's the goal. Physically get strong so that parent can come home. The adult child wants to get some things in place. Yesterday I spoke about the healthcare proxy. In this fact pattern, there is parent has money, maybe $100,000. Parent owns a home. Issue is, should the house come out of the mother's name? Should the house remain in the mother's name? What are the rules and regulations concerning removal of money from the bank account? Can that be done safely? Is it advisable? Does it trigger any period of look back, or does it forfeit? Does it, cause you to forfeit your ability to get Medicaid? So we're going in turn, we're hitting some things. So in this case, there was not an issue about dementia, not an issue about capacity. And the inquiry was about a power of attorney in this larger context. And as part of your estate planning toolbox, the elder law client, the person that's, that has a parent in this situation, the parent really should have a power of attorney so that the adult child or any trusted person can go to the bank, can potentially or possibly at some future point gift. Maybe possibly they could apply for Medicaid or long-term care services so that the person with the power of attorney can engage their financial analyst, their broker, right, their stockbroker, depending on what the person has. But even if you have little to no money, a power of attorney is a useful document to deal with Social Security, to deal with your insurance company, to deal with your cable company, to deal with National Grid or Verizon, right? So the power of attorney really helps the caregiver step in the financial shoes of the person that's in this situation. So I don't know if I want to go to the next topic. My topics usually take a couple of minutes. So again, we're working through this fact pattern, but a power of attorney is a useful document to have for a variety of reasons, and it's based on capacity. This is the other point. I often get calls where a child will say, my mom has dementia. My mother has the onset of dementia. My mother is forgetful. Now, in a non-therapeutic, non-medical reply to that, is the person, momentarily lucid? Are they intermittently competent? Can they sometimes know things? And, what is the standard? Well, do they know who they are, their name, where they are, the object of their bounty, what they own, what they have, who's important to them in their life? Can we engage in a conversation? I don't necessarily need them to tell me that today is Tuesday, but if it's day and they say it's night, then I know they don't have capacity to sign a document. So get your ducks in a row, get your plan in place in these documents before you face the issue of capacity. If you'd like to go over this with me, please go to frankbrunolaw.com.